Everyone, I am Prashansha Srivastava presenting legal headlines of the day on behalf of Law Mantra. The Cabinet has approved the appointment of former Chief Justice of Patna High Court, Justice L. Narasimha Reddy, as the Chairman of the Central Administrative Tribunal. As per an information note issued on Wednesday, necessary communication in this regard has been sent to the Department of Personnel and Training. Justice Reddy obtained a BSc degree from CKM College, Warangal, and bachelor's as well as master's degree in law, international law from the Osmania University. He thereafter enrolled with the Bar Council of Andhra Pradesh in February 1979 and was elevated as the judge of Andhra Pradesh High Court in October 2001. He served as the Chief Justice of Patna High Court from 2 January 2015 to 31 July 2015. He was the one-man judicial commission appointed by the center to look into the implementation of one rank, one pension scheme. The freedom that social media offers cannot be exploited to do online baiting, such as in the instant case wherein the de facto complainant is being branded as sexually promiscuous. The High Court of Kerala has recently observed that the platform of social media cannot be exploited to do online baiting. Justice Raja Vijaya Raghavan has made the observation while dismissing a plea for anticipatory bail to an accused politician who is facing accusations of having committed offences under Section 354A3 of IPC and Section 67A of the Information Technology 2000 and under Section 120 of the Kerala Police Act 2011. The applicant belonged to the youth wing of prominent political party of the state. The de facto complainant is stated to be a social activist and the wife of a member of parliament. The de facto complainant had recently published a book wherein she had leveled allegations of sexual misbehavior towards her by a leader of youth wing in a political party. The de facto complainant states that thereafter certain accused has posted several photos of herself and her husband on Facebook with scurrilous comment, most of them with sexually explicit content against her. The allegation imputed against the applicant therein was that he had tagged and shared the post of the same of the accused. These posts, it is said, have been liked, tagged and shared by many, including other accused. The applicant sought to justify his action on two courts. The first court, he stated that the revelation made by the victim in her book regarding sexual abuse against her garnered must be attention in the online and print media. The applicant, who used Facebook, had participated in such discussions wherein the alleged comment were made. On the second count, it is canvassed that Section 67A of the IT Act would not be attracted. Misplacing of files, omission of clerk attached to office of the council, etc. are routine reasons in most of the delay condonation application. Most of the court do not bother to check genuineness or validity of these reasons were through an affidavit by the litigants, especially when delay sought to be condoned is only a few days or months. The Sikkim High Court, while disposing of an application seeking to condone delay of mere 6 days, observed that no provision has been made in the Limitation Act for computing limitation for the carelessness of the council. Before the bench presided by Justice Meenakshi Madan Rai, a regular first appeal was listed with an application to condone delay of 6 days. One of the reasons stated in the application was the certified copy of the judgment impugned in the first appeal was misplaced on account of repairs in the chambers of the senior counsel engaged by the appellant. It was further stated that though an application for second copy was made before the trial court, it took 34 days to make copy available. Justice Rai referred to Section 12(2) of the Limitation Act 1963 and said clarification that the first certified copy of judgment was lost hold no water, as no provision has been made for computing limitation for the carelessness of the counsel. The court also retorted that the application on regular first appeal cannot be deemed to be filed unless all defects. The Bombay High Court has held that the cooperative housing society cannot be said to be an industry within the meaning of 2J of the Industrial Disputes Act. Justice S.C. Gupte was hearing a writ petition filed by Arihant Siddhi Cooperative Society challenging an award passed by the Labour Court, Mumbai, wherein the society's erstwhile watchman was reinstated with full back wages and continuity in the service was ordered. The respondent has been engaged as a watchman by society, and upon the completion of 60 years of age, his service was terminated with the effect from November 1, 2000, while the society argues that the termination was with mutual consent and the respondent disputed the claim. Although the respondent accepted the ex gratia payment given to him by society, he raised a demand of restatement. It was his case that he was permanent employee of the society and was terminated without any inquiry of or offering proper retrenchment compensation. The society resisted the reference and said that the services rendered by the respondent watchman were personal services, and the society not being an industry or the respondent number 1 its workmen within the meaning of the term under the industrial the central sexual harassment in his capacity as a citizen and accused under the RTI Act and under the principles of justice, criminal justice, to get all the related information to defend himself in a penal proceeding while imposing a penalty of Rs 25,000 on a public information officer for denying the information to an officer accused of sexual harassment at workplace and recommended disciplinary inquiry be conducted against him. The CIC Madhabhushi Sridhar Acharyulu has also criticized the CPIO for demanding Rs 6 for 3 pages supplied to the appellant by writing a letter. As the CIC said, the RTI rules say the CPIO can collect the copying fee at Rs 2 per page but did not authorize him to demand Rs 2 by spending more than that. This reflects at least the harassment nature of CPIO, which is surely a sign of malice, and the problem of CPIO is the mindset and attitude. It is part of malice. The public prosecutor cannot institute a private complaint taking cudgels on behalf of the person defamed. Quashing criminal proceeding against Dravida Munnetra Kazhagam member who allegedly made defamatory statement against former Chief Minister of Tamil Nadu, the late Jayalalitha. The Madras High Court observed that for the statement which do not in any way pertain to the public function discharged by the former Chief Minister, the office of public prosecutor cannot be used to file the private complaint. VPR Ilam Paruthi, a DMK member, had allegedly made some defamatory statement attacking the late All India Anna Dravid Munnetra Khajam leader, who was then chief minister. The public prosecutor then filed private complaint before the session court. That is all for today. Thank you.